welcome back. We've got a great book, truly one of the greatest legal stories ever, in my opinion. There's so much to talk about in this book, what we can learn, and also some of the tragic mistakes that were made. We have great lawyers joining us from across the country, as usual, and non-lawyers too. We want to hear from all of you. So please raise your hand when you have something to say. I know it can be frustrating when I can't get to everyone. I'm sorry about that, but please raise your hand anyway. We'll do the best we can. I want to add one new thing. If you have some general topic that you want to discuss about the book, write that in the comments section, and I will try my best this time to take a look and bring those things up. All right, Roland, hopefully you can come on and remind everybody how this works.
There we go. Remember to unmute. Lesson number 1, when you come on camera, remember to unmute. All right, so if the way it's going to work is if there's a topic that you want to discuss, raise your hand. You should find the hand raise button down at the bottom of your interface there. And let's just make sure everyone can find it. Go, everyone find it and push it and raise your hands, and we'll be able to see your hands go up. Boom, boom, boom. Everybody's raising their hands. Excellent. All right, and so then from my end, I can lower your hands, and then we can start from there. So when you raise your hand, we're going to bring you onto the panel. It'll take a minute. The little hourglass thing will spin around. It'll disconnect you and then reconnect you, and then it'll bring you on. So remember to unmute and turn on your camera, and you know, don't raise your hand if you're somewhere where it would not be good to turn on your camera. All right, I think I covered everything. Enjoy the club.
All right, so I think we're going to start with Ellen Relkin. She's very busy. She's in the middle of some really strict deadlines, but she agreed to come on for a few minutes tonight, and hopefully she's with us already. She practices in New York. She's one of the smartest human beings on the planet, a great lawyer, a good friend. She's going to talk to us a little bit about Schlickman's negotiation on behalf of multiple plaintiffs, which can be difficult. And she has a great story about Schlickman. So let me just, she was having a little trouble getting on. Looks like Ellen's not on yet. All right, so Roland, can you let me know as soon as she gets on? She has a story about Schlickman, and I know that several other people on here do as well. So as we're going tonight, please make sure you get your stories heard if you have a personal story about him. I love hearing inside stories or things that people don't know. We heard some great inside stories about Jerry Spence on one of our sessions about Vince Bugliosi. We heard stories from Scott Turow and Bruce Henderson. And I think Ellen is here now. So Roland, can we elevate her as a panelist?
Hello.
Hey, Ellen, how you doing?
Okay, how you doing, John?
I really appreciate you making time for us. I know how busy you are, but I promise we'll get right to it. So first of all, I was saying I love hearing inside stories about some of the greats, and we've heard from about Vince Bugliosi, Jerry Spence. Obviously, Bugliosi and Spence are some of the greats. You have some personal experience. We've all read the book. What do you think? Is Schlickman one of the greats?
Not sure about that. I mean, I love the book, and you know, he's certainly quite a charismatic and bold attorney. I don't know him that well. The little story I had was just, it was very kind of apropos of the sense we got from him from the book in terms of the Ritz-Carlton, you know, breakfasts and the kind of extravagant type of approach. It's really a silly story, but it was an AAJ dinner. It was AAJ had a meeting in Montreal, like, I don't know, probably about 15 years ago. And I don't know if somehow I got invited to a dinner where it was in a private room at some very nice restaurant, probably about 20 lawyers. And I guess Jan was the host. And it was classic. It was like a la the book. He ordered, what's the wine size that's way bigger than Magnum? It's really tall. He ordered one of those.
Magnum was the biggest. I don't know.
Oh no, it's bigger. It was like a $4,000 bottle. And he just ordered like these jumbo striped shrimp from Vietnam. I mean, just it was an incredibly extravagant. It's nice to be a beneficiary of it. But anyway, that was it. But fast forward, I don't know, a few years later, I was talking to someone about this dinner. And at that point, he had recently joined the firm. He had joined Huggins Berman, where he's no longer. But apparently, the word is that was a legendary dinner for them because he had recently joined the firm, and he then presented. It was like, I don't know, a $10,000, $15,000 dinner bill, and so that was like, welcome to Jan Schlickman. So that's the story.
Well, we're going to talk a little bit later after you leave about the way he spent money in the book and what we can maybe learn from that and get some comments on it. But in the meantime, I know you have a limited amount of time. Just real quick, can you look, I don't negotiate very often on behalf of multiple plaintiffs. And so, but it seems to me that he was not doing it right. He ended up with unhappy clients, and it just didn't feel right to me. So can you give us some of your insight on that and maybe some best practices on that and maybe some insight into what he did wrong?
Sure. Yeah. I mean, I was a much younger lawyer when that happened, when I read the book. It's been decades already, but it's in terms of aggregate settlements, there's the ABA rule 1.8G, which has been adopted in many states. And I know since a lot of you are Florida, there is an very equivalent Florida rule. It's your Florida Rules Regulating Florida Bar Conflict of Interest 4-1.8. So when you have an aggregate settlement, which is when you represent more than one client with a potential conflict, with regard to settlement, I'm just going to read the rule. Basically, the exact same thing in Florida as it is that was the cleaning staff.
Don't worry about that. We have stuff like that all the time.
Okay, so the rule is settlement of
I even already made my drink early today.
Oh, I'm jealous. I've got
Her day.
6 tomorrow. That's why I can't. I would love to be there for the
Yeah.
discussion.
So don't worry. Sorry about that. Go ahead.
No. So the rule is a lawyer who represents 2 or more clients is prohibited from participating in making an aggregate settlement of the claims of or against the clients unless each client gives informed consent in a writing signed by the client. The lawyer's disclosure must include the existence and nature of all of the claims or pleas involved and of the participation of each person in the settlement. So, I do a lot of these pharma cases, medical device cases, and what do we do when there's the possibility of negotiating an aggregate settlement? We write a letter to clients. We call it the aggregate settlement letter, and we kind of spell out, we've had ethics counsel who've given this letter, and we kind of just, tweak it. But the rule and say, but in this context, there's hundreds of cases or whatever, and defendants are not prepared to discuss individually. There is pursuant to this rule, there's a potential conflict of interest since we represent multiple people. However, we think this is in the best interest. And we recommend that you allow us to proceed with these discussions. Please sign the attached informed consent agreeing. And if an offer is made, the allocations are made. And usually what we do with allocations, by the way, is we get a neutral, a mediator, a retired judge to do the allocations. Or if it's a big enough thing and the defendants impose a matrix, that makes it easier because then it came from the defendants. So it's not like the lawyer, because we're not allowed to allocate. But then as part of this rule 1.8, where it says the disclosure must include the existence and nature of all the claims or pleas involved and of the participation of each person in the settlement. If there is an aggregate settlement and then there's an allocation done by a special master, we send a letter to each client saying you've been allocated, $200,000 based on the following criteria or whatever the special master determined, and the following other people who have similar claims have gotten the following amounts. We don't have the client's name. We're allowed to preserve their confidentiality. Might just have an initial. And then we have the amounts. So people know whether they got the lowest, the middle, the highest. And I think that satisfies this rule. So that's what we typically do. So what I forget I mean, I think the big thing is he didn't even disclose it to the client. I think.
Yeah, there was an offer that was made that he didn't even disclose.
Yeah. So I mean, so that's just clearly a major no.
Yeah, so those two things, the failure to disclose an offer, and then the way he was doing the settlement on behalf of multiple parties. I wanted to try and take a minute at the beginning and get someone who really knows what they're talking about. The rest of it, I think we can, we all learn from our mistakes, and he was kind of a pioneer in many ways. But those are two things we should learn right off the bat. You can't do.
Right.
So
Right.
I wanted to, I appreciate you coming on and telling your story and helping us with that. I want to hear from other people if they have thoughts on that, but I just want to take it out right out the beginning that this isn't a gray area. You can't do either of those things, right?
Right. Just to be a geek, the ABA Rule 1.4 on communications, it says a lawyer who receives from opposing counsel an offer of settlement in a civil controversy must promptly inform the client of its substance unless the client has previously indicated that the proposal will be acceptable or unacceptable, or has authorized the lawyer to accept or to reject the offer. So that's Rule 1.4. Now, I mean, the only place that gets kind of funky is if you have a defendant really trying to lowball you, you represent 100 people or 200 people, and then they throw out some ridiculous number, and you're like, forget it. That's ridiculous. Do you have to do this informed consent and notify everyone of a frivolous, ridiculous offer? Because then you get really bogged down in that. So I think that's kind of a, maybe more great. Technically, the letter of the law is, I guess, theoretically you're supposed to, but if it's hardly an offer, or maybe the way to protect against that is to know that your client has certain bottom lines, so you don't have to waste your time with nickels and dimes. But because I'm sure that does happen when they just kind of, throw out some silly number.
All right, great. I appreciate that, Ellen, and I really appreciate you taking the time. Maybe you can stick around a little more, but I know.
I wish I could.
I know how hard it was to take this time. So thank you. I appreciate it.
Thank you. I hope to join you guys soon. Take care.
Yeah, thanks, Ellen.
Bye.
All right, so let's bring Scott on, and if anyone else wants to comment on this before we get into the real dramatic parts of the story, I just thought we'd cover this up front because it's not a gray area. If anyone else wants to make a comment on that. And by the way, I know other people have stories about Schlickman, so whenever it's appropriate, raise your hand about that. We'd love to hear them. So Scott, what were you going to say?
Hey, John, how you doing?
Great, thanks.
I was going to say, I've got some of those cases. I don't do a lot of mass tort, but I have some of those cases with, large numbers of plaintiffs. They're very expensive. And if the settlement is such that fees and expenses are going to consume the entire amount of it so that the client would receive zero, I'm not sure that you have to, get the client's permission to reject that because there's nothing for the client to accept, really.
Yeah, I hear what you're saying. I never thought about that, but if you have a contract that ends up with a zero, it would be zero to the client. I don't know. I don't have an opinion. I don't really practice in that area. But look, let's talk about Schlickman's. We were going to get to it anyway. Again, I don't want to forget what a pioneer he was, and he was right. And I'm not sure anyone else would have taken this case. A lot of people had the opportunity and didn't. But there was a demand. An offer that was made that should have been passed on to the clients. It wasn't something that they would have ended up with nothing.
Right. I think you're right about that. The other thing, though, to keep in mind, and I don't know that this makes it any more permissible, but, keep in mind the context. That was 35 years ago. And while these rules may have just been in place the same as they are now, the kind of, for lack of a better term, maybe the industry standard was, everybody was violating that rule.
Yeah, I hear you, and I agree with that. I don't want this to be a criticism of him, but at the same time, we can learn from it. Okay, and so I think let me bring on Don Haviland too. I think Don had mentioned, he didn't raise his hand, but he had mentioned to me before. I hope that his video, when we elevate someone like this and they don't know it, I worry a little bit that I hope the video is okay. It's off at least.
He's
so
in his underwear or something.
Yeah, Don had been mentioning to me that that he thought clearly that should have been passed on. Well, actually, Don, you said that Schlickman should have told his clients to take that offer from Beatrice, right?
So I read that book. Can you hear me okay?
Yeah, we got you.
Yeah, I read that book right before I started working for Herb Newberg on class actions. And, that was one guy who, rest his soul, he passed in 92 of a heart attack at age 50. So think about that. But he had a way of kind of taking complicated things and just simplifying it from an ethics and practical standpoint. But I always thought to myself, why didn't he take the money? And my practice is multi-party all the time because I like having two and take the money, play with house money, and then go fight against the other guys. So, I read the book later on and realized that the obvious thing is he should have just taken the offer from Beatrice. It was the weaker case. Play with house money and then go after the bigger defendant and the bigger pot. My anecdote is interesting. We crossed paths in the Moakley Courthouse in Boston years later. I was in a case involving some Boston counsel who, unbeknownst to me, had crossed Schlickman, and I was having some issues over Rule 23 and representation. So I had a paralegal Google that firm and try to figure out their history. And I found out that there was this case involving Schlickman and this firm, and it actually involved the Kennedy. So now you got a nice little plot line. I see Mike Kelly. So it's Robert Kennedy Jr. has a nonprofit company represented by Schlickman. And they bring this case against this bigger corporation as a one-off case. And they bring in this other firm as kind of the big dogs, and they get the thing settled. And so I'm thinking, oh, the guy made money. That's good. He turned the page. Well, that firm then takes that concept, goes to another city and brings a class action using information from the Kennedy case, which they shouldn't have done. Kennedy flips out, sues that firm for malpractice. It goes to throws in federal court up in Maine. A verdict comes down against that firm. Anyway, long and short of it, the whole thing blows up badly, but Schlickman ends up being kind of like the whistleblower insider. And I'm walking down the hall one day in Moakley Courthouse, and one of my colleagues says, "Do you know who that is?" I said, "No." He says, Jan Schlickman. And I had to go up to him and I said, "Hey, I read your book, but more importantly, I know all about that water case that you had with Kennedy." And I said, "So I have a question for you. What's worse, the devil you know or the devil you think you know?" And he said, "What do you mean?" I said, "At least with the defendants, you know what you're getting, right? You get 1 and 2, you play it off. But with the plaintiffs, you never know what you're getting. You think you know, and they ended up screwing you because he lost that case, the Kennedy case, because it blew up when Kennedy sued. But you take the money, number one, and you be careful who you get into bed with on the plaintiff side of the bar." He didn't find it was funny at the time, but he emailed me a little afterwards and said, "I understand what you mean." But I agree with you, John. You look at this 35 years ago and what he did, he was really out there.
Yeah, he's a pioneer. We can learn from him, but he doesn't sound, that's another story that makes me think I wouldn't want to be partners with him. Mike, what were you going to add?
Oh, I was just going to say that So I hate being as old as I am, but I will tell you in 85 to 89, I had all these PCB cases against Monsanto and Westinghouse. And look, the strategy, this is, I'm sure you have a lot of younger people in this call, but you know, there was a time before ESI. There was a time when really everything got delivered to you in boxes, when you got 1 million of them, when the strategy was, if you were by yourself, to essentially, you know, get rid of all your resources. And if you were going to buy that $4,000 bottle of wine, it better be to close the deal because you had mortgaged everything you had. And the aggregate settlement was then and remains now really an effective tactic for defendants, either with underfinanced or underskilled or skitterish plaintiffs' lawyers, or those who are just, you know, on the verge of some personal bankruptcy. I mean, this remains a difficult problem. I actually can remember my contract with all my utility company workers, and also remember, you know, now people insert things that say if there's an aggregate, it'll be disclosed in a particular way. We may get a private judge. We may do all these things. You know, this is kind of pre the flowering of mediation and private judging. And look, I mean, you read that book. I read that book now, and I read it then. I read it then and thought I wouldn't have done this, but I don't think I would have been this deep into it. This is going to end badly. And I'm actually something of an optimist, although perhaps less so after 40 years on the day shift. And then I look at it today and think, you know, look, you get aggregate settlements all the time now, but they're in the context of an MDL. There's some judge who says, yeah, I'm going to approve a deal where everybody only gets 40 grand. And if you have the balls and the money to opt out, then you go try these lawsuits. The other thing is that, you know, Schlickman didn't have and nobody had was litigation funding. Whether it's a good or a bad thing is for a debate on another day in another book. But it's an interesting historical piece. And like Don, I actually met him much, much later. I don't know if he was suspended or lost his license. He was out of practice. He was back in practice, but he'd been out and back. And I met him at some AAJ meeting working on something else. I actually didn't talk to him about his book or his troubles, but I sat there thinking, I'm glad I'm not you. Most people look at me and say they're glad they're not me. Bless them. But you know, you think about those things. And so much is different today. I don't think you probably in most cases get in that spot today, but the lesson certainly is, I don't think whether the client's getting any money or not, I think you got to tell them. In fact, that's the first letter I send. I just got an offer that won't do you any good because I spent the money.
Yeah, well, that's talking about Scott's point, but that offer from Beatrice, you know, it goes to a larger question that, you know, some of you guys who've met him, I never met Vince Bugliosi, but I can tell from In the Sea Will Tell that he's one of the best trial lawyers ever. You know, Sandy Stern's a fictional character, but he's a brilliant trial lawyer. You can tell that Scott Turo's a brilliant trial lawyer. At the end of this book is Civil Action. I don't know if Schlickman is good in the courtroom. And I'd love to hear from somebody who has more knowledge than me, but I could second guess a lot of the things he seemed to do. And if you read between the lines in the book, it seems like other lawyers in the courtroom are telling Jonathan Harr, the author, that Schlickman didn't really do such a good job in multiple points in the trial. So I'd love to hear, so Scott, I'm going to demote you, you know, sorry about that, but just so we can get more people on, we got Rich Newsom and Carl Domino. I don't want to have too small circles, but raise your hand again if you've got something else to say. And we'll bring Rich and Carl on. And if Mike or Dom want to add anything or not, they can. Looks like they don't, so we can take them off. But let's see what Rich and Carl have to say about whether Schlickman's any good or not.
Hey, can you guys hear me?
Yep.
Hey, John.
How you doing, Rich?
Good, man. So this book is a little near and dear to my heart. When I, you know, it was, for those of you who don't know, I mean, this shows how old I am, but I just started being a plaintiff lawyer when the movie came out with John Travolta. You remember that?
Yeah.
You ever see it? So I read the book, and my wife and I go see the movie, and we were just, you know, building a house. We were trying to have kids. I still had student loans, and I just started with a small PI firm. And we go see it, and she was very quiet coming out of the movie theater. And she looks at me sort of sheepishly, and she says, could that happen to us? It was like, oh, maybe, I wanted to chime in. I was going to try to shut up because my mouth is always running in these. I want to, let others speak. But one of the things I would try to throw out, and for anyone here who hadn't read the book, it's this epic story of this David versus Goliath, and just he was followed through the entire trial by this journalist, and the whole thing was written up. And this guy basically lost everything in this case. It was just heart-wrenching and sad. And the clients were upset and pissed, and it was a horrible case.
And can I just add, and it was really a failure of the justice system, because it was a righteous case. Some of the science came out a little bit after, but it was a hostile judge, at least from what we could tell. And he was getting railroaded. And he did get railroaded, and all those families who lost kids got railroaded.
Absolutely. And this was really before mass torts. This was a time when the mass torts industry was really starting to get, it was asbestos had kind of happened, and that had been going on, but it was right during the time that breast implant, which was the second really big mass tort. It was before tobacco. And so it was a brand new industry. And, today, and I would love to bring Mike Kelly back on to get his thoughts, because he made a comment about that. He said that this probably wouldn't have happened today. And so for a lot of our younger lawyers, that's something I'd like to explore. I mean, what happened, and by the way, for those of you who know Mike Hugo, my personal Jan Schlickman story is not firsthand, but Mike Hugo is a lawyer that a lot of folks who are involved with AAJ know. Mike has been on the section on toxic and environmental. It's called STEP. It's their toxic tort group at AAJ. He's been in their group for 30 years. Mike knows everybody. And Mike is from where Jan Schlickman lived. And actually, Schlickman ended up sleeping on Mike Hugo's house, or sleeping on his couch after he lost his house. And Mike had all kinds of stories about, because he lived through that. And Mike wasn't in the book, but was personally a witness to a lot of what happened. And so I remember hearing that back then, and that, I struggled with what would I have done. And so I'd like to throw out to the group, Mike mentioned litigation funding, and today we have MDLs and we have large groups of people, but I'd like to ask, Mike to follow up with, how, as a young person looking at a big litigation, so this giant case walks in your room where it looks incredibly difficult. It could be a toxic tort, it could be something else. How can this not happen, especially if you're with a small or medium-sized law firm? How can you avoid the tragedy of, bashing heads against a big litigation with incredibly well-funded defendants in a complex case, and live to come out the other side? So I'd love to hear Mike and anyone else's thoughts on that. And that was it was something as a young lawyer I really struggled with, and it scared the shit out of me. And so I'd love to kind of hear thoughts from the group on that.
Well, I'll make one comment. I mean, and I'm fairly conservative when it comes to stuff like that. But if you're out of business, you're not doing anyone any good. You have to understand how much money you have and where the limits lie, and that's why sometimes you gotta have co-counsel. The problem for him was it appeared no one else wanted in on this case. But I think he put too much of himself in, and look, he wasn't a big enough lawyer to do what he tried to do. And that's it's tragic in a way, but it's delusional too. So if I had one criticism of him, he wasn't, look, I could say this about myself in every trial I've ever lost, or every time I've negotiated a weak hand and wanted to punch myself in the face, so like disgusted with myself because I've got a weak hand and that's all I can play. But let's say it's true about me, and sometimes, and it's definitely true about him. He wasn't a good enough lawyer to do what he thought he could do. He wasn't as good as he thought he was. I don't know if that's practically helpful, but maybe Mike or Carl, Rich, Mike was, so we'll get to you, Carl, don't worry. But Mike, Rich was directing that at you.
No, look, I think there's a bunch of stuff there, and but you have to also understand in the context of whether there wasn't the kind of networking there is now. There wasn't the kind of communication there was now. There were people, and there were big problems with causation. I mean, there are still problems with toxic tort causation, proof of cancer or heightened risks. The law had not, the law is always slow to follow the science, or the science is slow to follow the law. You're screwed either way, and we're out there taking the risk. I agree with you, John, that this is not, there's some romanticism. There is some tilting at windmills with one person taking on the major chemical corporation, but it didn't make any effing sense. And, you don't know, is that just a function of nobody else wants in? I don't like the risk. I don't like the odds. I'll play somewhere else. How much of it is ego? I mean, I just think that the central issue here remains on the duty to disclose. But I do think this, for a smart lawyer or law firm who wants to find partners, there were that many toxic tort lawyers. And by the way, the original toxic tort lawyers, for the most part, didn't know shit. They just got retained by somebody whose child died of a cancer, or who got leukemia or got poisoned. I mean, look, my firm and one of my partners was in the Love Canal litigation. We all should have been locked in our fucking rooms for 5 years and never allowed to sign up new cases after that. For me, I think you see it correctly. I think there are problems there. I just don't think now, if a small law firm finds a case, works up the causation, can do it, they can find ethical partners, and they can find ways. There's no excuse for not making the appropriate disclosure to your client. And I'm not trying to sound like Snow White on that, but for self-preservation, you can't put money ahead of ethics or integrity. And this is not like, you're the first person to have this. Most of these problems other people have faced and fixed. And so trying to reinvent the wheel, there's no upside to it. Carl, go.
You're muted. There we go.
Just to throw something out, more of a business person and lawyer. What struck me is they did a very detailed decision tree analysis and conclude the case was worth 0 if they lost and 40 million if they won, with 24 being the expected value. Then they have a 2-hour dinner meeting with a brilliant Harvard a brilliant Harvard academic who got in their mind that this is $1 billion case. Doesn't make any sense to me. Don't have any other, as a business person who's negotiated big deals, that makes no sense. You got to go into negotiation with some sense of reality. How do they lose sight of that 0 to 40 million and jump to the hundreds of millions? Does that make any sense to any of you?
Yeah, and you don't forget, he wanted to settle. He did want to settle. He just wanted, at least with one of them, he wanted to do it his way. He certainly wanted to settle after the verdict within the second settlement, and they just left him twisting in the wind because they knew they had the leverage. So that's a good point, Carl. Let's bring Earl on as well. He's got his hand raised and see what he has to say. And then we'll move on from the financial part of it. Go ahead, Earl. You got
Not Earl. I'm sorry. Are you guys all disappointed? It's Aaron.
Oh, Aaron, I should have known by now. You've done that to me before.
I know. I'm sorry. I always use my husband's because his is already ready to go. So that's what you get for being married to your law partner. So our situation, because we are married and we have our firm together, is very difficult because we pull from the same, we don't have a fall back if we don't get our cases done, right? And we have 4 girls. And so that's always a concern to us. But our safety net, which is crazy, has always been our parents, right? So my parents, they bought us a house, and said, when you have a chance, pay us back, right? And so we've been really lucky. And so I feel like a lot of times so I have a website called Lawyers Are Tools, because really that's what I found out. I'm not like brilliant. I'm not amazing. I'm not great at what I do, but I have realized that, I am a tool in the shed for people that need it, but I have tried lots of times to get other attorneys that are successful, great attorneys that know what they're doing a lot more than I do, to take cases with me, and I can't get them to. I don't know, maybe it's me, I can understand, but so I don't know what's the goal of how to get somebody to pick it up, because most of my cases, everybody says there's absolutely no way you're going to win on this case. And I think that people have a hard time valuing cases that need to be taken, that they won't take them.
So if anyone else wants to respond to that, you can raise your hand, but I'll give you my thoughts on it. When we first started our firm, we took cases that we wouldn't take today, right? So so that's the problem when you're taking cases that should be taken, but if you get in a position where you want to co-counsel them, now you're in a situation where there's a co-counsel lawyer, there's a split in the fee, and it may be a case that another firm isn't interested in taking. My advice to you on that, there's three things you can do. First of all, you can be successful on those cases just asking for advice and keeping the case yourself. Another possibility that you have is trying to have lawyers that are about your age and about your stage in career who you work with. Sometimes you do cases together because occasionally, just because there's a lot of work involved or it's starting to overwhelm, and you do that for each other. And then the third thing is to really look at the case and make sure it's one that should be taken and should be taken by you, rather than just that you've become emotionally involved in it and it's not a case that anyone really should be taking on contingency. I don't know, does that help at all?
Well, I still think the third one is questionable, because again, I mean, I've taken some cases where I have had the lawyer say there's absolutely no way you're going to make any money out of this. And then I've gotten, $1 million settlements, and so I think that the value of a case shouldn't necessarily be the money value of a case as much as people want to make it.
Well, yeah, you're absolutely right about that. We all should be, and I think hopefully most of us are taking cases where we're not making money on them, but you can only take so many. Each of us can only take so many, and you're saying something different. Like whoever you went to was wrong when they said you'll never make money on that case when you got $1 million settlement, right? So maybe that's not the person you should be asking for advice anymore.
Well, that I agree, but that's how everybody is here. No offense to everybody in Oregon, but every case I take, that's the result I get from the other attorneys if they want to co-counsel. And so I think maybe it's because I don't have an established, firm with a whole bunch of the clout, right? So I take the cases that are a little more risky because those are the ones that come to me. While, the other individuals, they take the cushy cases because they get the pick of the cases. And
Yeah.
So it almost seems like, is there a possibility that the individuals who are have the cushy cases that have the clout are willing to ask the younger lawyers to come in and help them, so that we get the experience that we need to get our own clout?
But I listen, you took a case that other big firms wouldn't take and you got $1 million. That's your clout. You don't need them to come and kiss your ring. It doesn't matter what they say. You're building your own practice. And I'm sure that defense attorney knows, and he's mentioned it to people. I don't think you build your clout by you will, in fact, I will tell you, you will never get any clout when you co-counsel with a larger name. They'll take everyone will assume it was all them. You have to do exactly what you're doing. And it sounds to me like, you just need a few more years. You take those cases and keep getting great results. And then those lawyers who obviously can't tell $1 million case when it comes in, their clout's going to be going in the other direction. Jim, it looks like you wanted to say something. If I'm wrong, tell me I'm wrong.
No, John, hope you're doing well. I'm probably one of the few people on here actually older than Kelly. And I remember
I didn't know that was possible.
But what we have today, I mean, it's like comparing the Corvair to the Tesla today. I mean, back then, Jan didn't have the resources. He didn't have the networking. He didn't have the sounding boards. He didn't have the people. He had a belief. And we know from the fines that happened later, he was right.
Yeah.
As to what happened. But today, if people don't avail themselves to what is out there in the market with co-counsel, with understanding who the judge is, what is that circuit rule on these things? It makes it a lot easier today. I was involved in one of the first Bendectin cases, if you may remember. That's a long time ago. And we didn't have those resources available until I think it was Barry Nacer. One of the other ones actually hit him and the documents came out, but you can remember those days also. They hid the ball on Jan. He didn't get the materials that he really needed, and he felt and he knew in his heart they were there. He did make some mistakes. There's a difference between a would you take and here's an offer. Offers you have to take to your clients. Would yous you don't. And I think that he got adrift, but trying to look today as to what's out there compared to back then, it's apples and oranges. We have so much more available. We have people like you and Rich and Mike and Don, who I'm working with now on a matter, as sounding boards, and nobody's as smart as everybody. And it's a sad tale with so many mistakes that were made along the way. Some of his doing, and some of them weren't. He just didn't have the materials available to him.
Yeah, I hope it wasn't in the talk so far. It hasn't seemed like we're just beating up on him. His strength is his weakness, and it's just my opinion. But he went where I wouldn't go, and he got something done that I couldn't have gotten done. So you have to admire him for that. But I also think it's fair to look at the things he did wrong so we can learn from them. Besides the fact that he took a fight that maybe some of us wouldn't have. And by the way, you're right. I mean, he got something for those families. They got railroaded, but he got something for them. He got some measure of justice. So I wonder, and we've got a couple other hands raised. We'll bring on Don since you mentioned him, Jim, and we'll bring on Madeline too. But what do you guys, I mean, was there a way, was there anything could you have taken this case, Jim, and won it, right? And don't I'm not asking that knowing what we now know, which Schlickman didn't, were there things he could have done differently that would have had, or was it with that judge, was there no chance?
No, I agree, no chance. And he's doing cutting edge things, the pump test and all the things with the chemicals. I mean, it was a marvelous effort. It was just misguided in some places. And part of that was he didn't have any place else to turn. He was out there on a limb by himself, and he did make some mistakes retrospectively. But as we go along and we really start believing our own BS, and we really think, oh, I can do this, and then the judge threw him for a loop. Yes, he should have taken that settlement. As Don said, played with house money. That's always the best. But he just got carried away.
All right, so why don't Don and Madeline, let's go. Who raised their hand first? Let's see. It was Don. Go ahead, Don.
Let me, I wanted to say one thing to Aaron, because I saw a comment come across that how do you make these decisions when you're struggling with student debt? Someone said that. I don't know if you saw it, John, but is that you? So I just want to make a couple observations. So I'm 55, and I had to reach out to the guy down in the lower corner there, JB, recently on a case to get some consult. And you'll find that when you do that, when people think you know everything, but then you reach out to somebody, you really don't. And just getting a sounding board from somebody, and JB doesn't do what I do for a living, but we're working together on this case. And if I didn't have him to call, I think I'd go crazy on some of the issues you have to deal with. So that's point number one. Make the phone call. You'll always get, I just think you'll get a receptive audience. The bar, especially for plaintiffs' lawyers, is very, very congenial. You know, what Rich does and what John, what the groups do, you have more resources than when I got out of law school. You sat at the foot of the table and you watched the senior lawyers do what they do. So there's my second point. I don't know what's going on in Oregon, but I tell you, here in the East, I practice in the tri-state area. And just in the last 2 weeks, I've had 3 federal judges order that we let younger lawyers argue, let younger lawyers present. And each one said to the senior lawyers, we will not fault you for that. We will encourage you and we won't embarrass anyone. We want younger lawyers to get that opportunity. And I said, wow, that's really good to hear. So I think that the bar, the judges are starting to listen. And so my message, don't be afraid, go to court, because the judges, I think, are going to be receptive to the fact that you came. And that's I think that's a refreshing thing to see that I didn't see coming up. I always saw the gray hairs sitting there and you were waiting your turn. And in some cases where the risk's so great, you never get that shot. So take your shots, because I think you'll find a receptive audience, both from the bar and from the bench.
All right, thanks, Don. So we're going to hear from Madeline now, and then we're going to go to do our 4-minute learn a new drink. I promise it'll only take 4 minutes, and then we're going to come back and talk about some specific, I want to know how you guys feel about some mistakes and things that Schlickman did. I'll have some specific questions, but let's hear from Madeline before we go to the bartender.
So I wanted to say, and this kind of addresses maybe what Aaron was saying. Sometimes you take a case just because it's the right thing to do. You know, when I took the first tobacco case in 1998, nobody was winning tobacco cases. It's not like the you know, the wonderful Florida results that are in existence now. This was really the beginning of it. And in fact, the tobacco companies had been immune. And I had to fight with my partners because 2 of my partners says, you're just going to waste our money. This is just going to cost a fortune. You know, go out and try an asbestos case. Leave the tobacco cases alone. And, you know, this was the days of boxes and so forth. And me and my paralegal flew across country to Jacksonville, Florida, to meet with Woody Wilner, who had won 1 case, but no punitive damages. And, you know, we basically raided his cabinets and took photocopies of things and came back with boxes, and he sent us boxes. And, you know, I really had no expectation of winning. And, you know, like I said, I had to fight with my partners because they didn't want to spend the money on something that they saw was a losing cause. But sometimes you've got to take it on. I mean, you know, and tobacco was definitely it.
Yeah, I just, it would be nice. You can't tell this ahead of time always so carefully, but if you could take cases like that and not lose your house, your car, you know, have your computers taken from your office, the phone bill shut off, and he had 3 mortgages on his house. He was being sued by Amex. So, you know, I'm not going to criticize him. Am I? Maybe I am going to criticize him for that.
Yeah,
I mean,
I think
you're not
I
helping
think you're
anyone.
saying he had no business taking that case. I had no business taking the tobacco case either.
You didn't lose your house? What'd you do different? I'm assuming. I hope.
Well, you know, we didn't get paid for over 10 years. It went up and down a million times in the appeals court and everything. So, you know, my partners barely were talking to me because they weren't getting their bonuses, because I had spent all their money and I had nothing to show in return except for a verdict.
Yes,
So, you know, I may not have lost my house, but I sure didn't have a lot of mortgage. I mean, you know, money to pay the mortgage every month.
Yeah, but so you're showing moral courage in the same way that Schlickman did, but you did it in a way that was more helpful, or at least somehow safer to yourself. Let me ask you guys one other question before we go to the bartender, because it's not just a financial risk. And they mentioned this in the book, how he thought he had put too much into one case, or too much of himself. You know, there is some type of psychological risk that I think I said Rich, because Rich has talked about some of the getting control sometimes when you're nervous in the courtroom. And I have seen lawyers after they've lost a case, it has become much more difficult for them, not any case, but especially a case that you pour yourself into and you lose, that there's some type of psychological ramification that affects who you are in the courtroom. So, you know, we've talked about the financial risk he took. Does anyone want to say anything about, I think I just raised my hand, guys, by the way, that was a mistake, about putting too much of yourself into a case? What do you guys think about that? Is there a risk there?
Absolutely. I mean, I was so invested in this case. You know, I lived it, I breathed it. My trial assistant came and stayed at my house. My husband cooked for us. You know, it was everything that I really lived and breathed for a long time. And it is hard because, especially when you're making law, you don't know how that's going to turn out. I mean, you know, there was never a point that I had a safe, you know, feeling about that we were ever going to collect on this. You know, and my client kept saying to me, don't worry about it. We're going to make money on this. So, you know, I'm going to stay alive and because I want Philip Morris to give me a check. You know, so, but you do, I lost myself for quite a while in that case, to the detriment of other cases that my office was pursuing.
All right, well, so we'll conclude that I'm wrong, because we can't judge Schlickman just because he failed, right? We have to look at them as taking the moral risk. And then ironically, we have a psychologist, I just see raising his hand. Will you elevate Dr. Crown? Let's just hear from him, because I think he raised his hand when I said psychological risk, and hear what he has to say. And then we'll go to the bartender. Dr. Crown, your video, yeah, there, now we can. Now
there we go. Hi, I'm a psychologist, a neuropsychologist, but also I have a law degree. But my experience, and I've been involved in mass tort cases, I've been involved in tobacco cases and so on, and practicing in the 1980s when Schlickman was active in the Woburn case. But my general experience in dealing with trial lawyers over the decades is that trial lawyers tend to let their egos or their self sort of run away from themselves, and that usually works. But when the bills run up, they don't really account for that. They're more interested in their self-worth, which is measured by accolades from their friends and number of verdicts, rather than what they're experiencing. And that's the psychological part, I think, of being a trial lawyer. If you don't feel good about yourself and you don't continue to feel good about yourself, you're going to characterize yourself as a loser, and you're not going to be able to put forth the effort or the vision. Trials are always theater, as far as I'm concerned. And a good trial lawyer manages to run the theater. One of the characters in the book and in real life, Ricky Kleeman, she's told me often that her main goal in life was to be on Broadway, and the best she could do was be in the courtroom. So that's just my comment from a psychological standpoint.
You know, I think that's really quite insightful about trial lawyers, at least many of the ones that I have known. My first boss, who Dr. Cron, you know, he really only hired people that he thought were damaged in some way. You know, it's probably not healthy if, like you said, that we judge our self-worth based on accolades, or what other, you know, our other fellow trial lawyers think of us. But I could see that being more important than money. Probably a lot of the people on this can, and it may not be healthy, but it has the ring of truth to me.
I think it does, but Schlickman lost that race. He got ahead of himself in thinking about whether he was going to have a suite at the Helmsley or whether he was going to have a meeting at the Ritz-Carlton for part of the theater. And you have to be a good theater director.
All right, so on that note, let's go ahead. We're going to hear from Mac, our bartender in the East Village in New York. It'll only take 4 minutes, so stick around even if you don't drink. If you're interested, I made mine early based on his recipe. It's good. So let's see how to make this, and we'll be back in 4 minutes. I better come back until we actually see him. There we go.
Hey,
how you doing, Mac?
I'm good. Good to see you.
So you're at home, you're not at the bar.
I am at home. I'm not at the bar. Super excited. I feel like next time I might have to just read the book along with everybody. I always feel like I'm missing out on such a nice, stimulating conversation, so I can just follow along.
This one's a good book. I mean, it's a bestseller. People, you don't have to be a lawyer to enjoy this one. All right, so I'm going to leave it to you. Thanks to our volunteers, and let's see how you guys make your drinks.
Okay, everybody, let's get ready. Today we will be making something called an old Cuban. Super delicious. It's a modern classic created by one of the owners of the Pegu Club. Really easy and easy to make for everybody else that's following at home. May not be making it right now, but making it in the future. So, real quick, we're just going to go over everything we need. Remember, we need lime juice. We're going to be doing 2 dashes of Angostura bitters. We're going to have some mint, some aged rum. If you don't have aged rum, you can throw out whatever rum it is that you have. No worries. A little bit of simple syrup, some dry sparkling wine, and voila. So let's go ahead and get it going. I'm just going to go ahead and unclick that. Boom. Now you guys can see what I'm doing. Follow along with my hands. We're going to go ahead and put 3/4 of an ounce of lime juice. All right. Right into our jiggers, right into our tins. Follow along. We're going to do this nice and quick. All right. Next up, right after you get that lime juice, we're going to do 1 ounce of simple syrup. Now, if that sounds like a lot to you, just do ½ an ounce, shake it up, taste it, and add more if you need to, all right? Always start small. You can always add, you can't take away. For those of you that wind up getting some Angostura bitters, you're gonna put 2 dashes into our tin, just like so. And then of course, we are gonna be doing our rum. So we're gonna be doing 2 ounces, or excuse me, 1½ ounces rather. All right, 1½ ounces, our jigger right up in there. And last but not least, go ahead and grab some of your mint. You can just eyeball it. I'm taking about like 6 to 8 leaves. Just go ahead, break them off, throw them in there. The next thing, final thing, grab some ice. Throw some ice in your tin. Only fill up about 3/4 of the way. You don't need that much ice. Then we're gonna give it a hard shake, right? 2 hands, slight twist, circular motion, follow along, right? There you go, looking good, looking good. All right, go ahead and pop that open. Now, if you have a mesh tea strainer, go ahead and grab it. If not, don't worry. I'm just gonna fine strain mine right into my glass to get all that little, those little mint pieces. And for me, my fiance is actually allergic to sparkling wine, so I'm just gonna top mine up with a little ginger beer. Once you got that done, go ahead and just top your cocktails off with sparkling wine, or like I said, if you're allergic for any reason, put some ginger beer, put some club soda, something dry. And then we are just gonna take our mint. I'm sure you guys have seen this before. Give it a little slap right on our back of our hand. We're gonna express those oils. I'm just gonna lay it right on top, just like that. And voila. There we go. Everybody's looking good. Come on, you got it. Looking good. Get up there.
Nice, nice. Those are looking great, Megan. Nice, fantastic. Awesome. Scott, boom. Here we go. Well, cheers, everybody. I hope it tastes fantastic. Super easy. Kind of like a rum mojito. A little bit of sparkling wine. Absolutely delicious.
Thanks, Mac. What do you guys think? It tastes good, doesn't it?
Oh yeah, fantastic. I haven't seen
It
these
tastes amazing.
all night, I didn't realize.
All right, thank you, Mac, and thank you, volunteers. This one is a fairly easy to make drink and very tasty. So thanks to all our volunteers.
Thank you very much for having me. Hope to see you guys again soon. Have a great night.
Hopefully we'll see you live one day soon.
Thanks, guys.
All right, so now we're switching to a couple of topics. We'll probably just have another 10 or 15 minutes, but I want to see what everybody thinks about a couple of quick things. Let's talk about Rule 11 and personal attacks on the opposition. This is an interesting thing for us. Schlickman didn't do it. The Rule 11 motion was filed by his opponent. And then there was the barratry and other personal attacks he kept making on Schlickman. There was some probably strategic advantage to it. It certainly mattered in the end. So I'd like to hear what you guys think about those type of, do you ever make attacks like that on your opponents for tactical advantage, even when they deserve it? What do you feel? How, do you feel that Rule 11 is underused and we should use it more? And how do you feel specifically about what the lawyer Cheeseman did to Schlickman? So let's bring Scott on as the first person to discuss that, and I'll give you some of my personal thoughts. What do you think about that, Scott? You're muted. Today has to be the day with the most technical problems. We started with the technical problem. We went technical. I apologize for that. We all do it sometimes, but today seems to be, we're all in a funk. But anyway, sorry, go ahead, Scott.
Well, I was just going to say, that's a pet peeve of mine, and I feel really strongly about that. I've spoken to judges about it. I don't think Rule 11 is an effective remedy to deal with it. It's even if the rule sort of lays it out, courts don't want to see Rule 11. You have, the safe harbor provision of Rule 11 where you have to talk with them, serve them the motion 21 days before you file it, things like that. I think the courts have to police it. I mean, in my litigation, I go to great lengths never to attack the other lawyers. And I don't even identify them by name. And in a lot of litigation I'm in, the defendants, I think they learned this at DRI or something because it's so consistent. They attack the lawyer by name and they want to make it about the plaintiff's lawyer and not about the client. And one, it's very stressful to deal with that, to be on the receiving end of it. It's very stressful. It makes litigation really unpleasant. I think it's really unprofessional. But I think lawyers like us who have, friends who are judges have to beat this drum with them and emphasize to the courts that when a judge gets a brief like that that's attacking the other lawyer in name, they have to do something sua sponte about it. They really should. Because one, I don't want to spend the time writing a Rule 11 motion to deal with, a series of attacks on me in a brief or something like that. Maybe if it goes on and on and on, at some point it crosses a threshold. But by and large, defendants get away with it, and because they know that it's just going to be a lot of time and money for the plaintiffs to deal with it, they're going to seem petty when they do. And at the same time, I think the defendants believe there's some subliminal effect over time that calls the credibility of the plaintiff's lawyer into question in the judge's mind.
Yeah, and I think it's effective. I think it works. We had a case recently where one of my partners, it was a bad faith case. And the bad faith case against the insurance company involved the insured, and the insured had hired her own lawyer because the insurance company refused to defend, even though it turns out there was coverage. So in her deposition in the bad faith case, she was unrepresented, and she said that her lawyer told her that she was going to get beat if she went to court. And she misspoke and said my partner's name instead of her lawyer's name. She said she was going to get beat if she went to court. So they took that quote that she was going to get beat if she went to court, which they well knew, the insurance company lawyer well knew that she had misspoken and it was her lawyer, not my partner, and said that my partner threatened to beat her if she went to trial. And that's why she signed the paperwork. But I got to tell you, that was very stressful for me. I can't imagine how stressful it was for him that he's being accused in a federal court of threatening to beat a witness. And there was something else, I think it was about me. I can't remember what the second thing was that was just as bad. And I found it it was very stressful. Every tobacco appeal that we have after a tobacco verdict, I read often some significant time has gone by between the verdict and the appeal, and I read it and I think, what the hell was I thinking? This is clear error. I'm a horrible person. But of course it was all manufactured. So I don't know. We don't do it back, and I don't think we should. But I'm open to hearing what other people think about how Schlickman didn't do it back, and in the end, it fucking killed them. In the very end, that's how the judge got.
About that, John. Let me just say two more things really quickly about that. One is I think that calling them out, even if it's a sentence where you say, I'm not going to address the ad hominem attacks or something like that, to sort of flag it for the court so they're thinking about it. And sometimes, calling the lawyers out in a meet and confer, I don't know how much use it'll have, but sometimes it makes people self-conscious about it when they're doing it. The firms that we deal with, the Gibson Dunns and the, large firms like that, they just sort of, there's like no accountability. They have one person writing the brief and someone else arguing the motion. And they don't even know what the person writing the brief had to say. But I think that that's really important. And I think consistently adopting, maybe through trial school, maybe through Rich's work, we adopt some kind of a strategy on how to confront that across the board by lawyers. All the members in trial school adopt a kind of similar strategy, talking point, whatever it is, and deal with it. And also take advantage of talking to the judges that are our friends. We're at that stage in our life where, we have friends who are state and federal judges, and we have their ear, and at least plant that in their mind. So the next time they see it in some case you're not involved in, they call that lawyer out for it.
Yeah. I like that. Good advice. So everyone start talking to your friends who are judges. And it goes both ways. There's some plaintiffs lawyers who abuse that too. And it just shouldn't be abused.
Right.
All right. So thanks, Scott. I appreciate it. So a couple of things to finish up. We try to go close to 60 minutes. We've been aiming for 75. We did a poll on that, by the way. I don't know if you guys remember, and most of the people were in 60 or 75, not 90 minutes. So I'll start wrapping up, but let me just say, in 2 months, we're doing it every 2 months instead of every month, so you have time to read it. And we're going to start sending emails. Email me if you don't want to get inundated with emails. I feel bad doing it, but people forget, and what they particularly forget is to start reading the book. So by the time that we get close to it, a lot of people are emailing me and saying that they're not done. So we're going to send out emails this week, tomorrow and next week, reminding you to go ahead and get the Fall of the House of Zeus. It's wow, it's fascinating. And once again, we've got one of the truly great trial lawyers, and we can see some mistakes that were made, and also potentially how he got railroaded. It's a fascinating story. If you haven't read it, you need to. We'll start sending that out. Great book, Fall of the House of Zeus. And I also want to congratulate a paralegal who I've been working with since 1995 or something, at Sheldon Schlesinger, PA. We worked on the McGee case together, our first trial in 98 or something, which was a landmark verdict. She just got paralegal today, paralegal of the year from AIAT. I'm very proud of her, Raina Williams. She was known as Raina Truccio back then. And I think that's it. So we'll get out Fall of the House of Zeus. I really appreciate everyone participating. If you have any questions on anything, send me an email, and see you in 2 months.